We'll start now. Good evening and welcome to today's webinar. The topic, as you all know, is the Dharani Sugars case and its implications for the IBC. I will now share my screen so you can all follow the PowerPoint slides from this presentation. I'm Aparna, Ravi, and I've got with me my partner from the Mumbai office, Khyati, Sanghvi, and we'll both be talking about this case as well as the implications for the IBC landscape. We'll speak for about 30 to 45 minutes, and then we will take questions after that. So without further ado, we'll start. I hope everyone can see the screen in front of me. So first of all, it's interesting to know that this case did not actually, challenge any provisions of the Insolvency and Bankruptcy Code at all. In fact, the constitutionality of the IBC itself was upheld recently by the Supreme Court in the Swiss Ribbons case that was in January. What it did do, however, was challenge the RBI's powers to require banks to actually initiate proceedings against companies under the Insolvency and Bankruptcy Code. And here, the petitioners were various power companies, and they said that basically the RBI could not have this kind of monolithic approach towards all companies, that the power sector suffered from very specific issues and stresses, many of which were beyond their control, and therefore the whole validity of the RBI being able to mandatorily refer cases to insolvency, to the Insolvency and Bankruptcy Code, was not constitutional. So specifically what the case that petitioners challenged was, first of all, the constitutional validity of the Banking Regulation Act itself, in particular sections 35AA and 35AB, which were passed by an amendment to the Banking Regulation Act in May 2017, and also, most importantly, the RBI's February 2018 circular on the resolution of stressed assets. So before going into the specific case, it's interesting to just go through some background on the RBI and the various amendments to the Banking Regulation Act, as well as the actions that the RBI has taken since the IBC came into effect. So the Insolvency and Bankruptcy Code came into effect in December 2016. And thereafter, in May of 2017, there was an amendment to the Banking Regulation Act. And this amendment was basically intended to empower the RBI to issue directions to banking companies on the resolution of stressed assets and initiating corporate insolvency resolution process proceedings under the IBC. Specifically, it added section 35AA to the Banking Regulation Act and 35AB. And you can see the specific provisions on the slide here. But basically, section 35AA gave the RBI, with the authority of the central government, powers to issue directions to a banking company or banking companies to initiate insolvency resolution process under the IBC. Section 35AB dealt more generally with give powers to the RBI to issue directions to banking companies for resolution of stressed assets more generally. So there are a few differences between section 35AA and section 35AB, which are worth pointing out here. First of all, the section 35AA actually requires an authorization from the central government. So that the central government, if the RBI has authorization from the central government, then it may issue directions to initiate proceedings under the IBC. Section 35AB doesn't specifically have any requirement of authorization from the central government for the RBI to issue directions for resolution of stressed assets more generally. The other difference between Section 35AA and Section 35AB is that 35AB actually also refers to Section 35A. So it says without prejudice to Section 35A. So the two have to be read in tandem with each other. And what Section 35A is actually a broad power of the RBI. This was in existence even prior to the banking regulation ordinance coming into effect, which is a broad power to the RBI that it could issue directions to banking companies from time to time on matters in the public interest, in the interest of banking policy, to prevent the affairs of any banking company from being conducted in a manner detrimental to the interest of depositors, or to secure the proper management of a banking company generally. So this was a pretty broad direction, and 35AB says that without prejudice to this covers under Section 35A, the Reserve Bank of India could also issue directions for resolution of stressed assets. So these were the amendments that were made specifically to the Banking Regulation Act in May 2017. And the idea here was that, and it's quite clear from the statement of objects for this amendment, that the reason was that the banking sector, there were a lot of non-performing assets, the number of stressed assets was very high, and the RBI wanted to be empowered to ensure that banks made effective use of the IBC. Even though the banks were entirely empowered to file under the IBC, of course, it was under the code itself, it's completely at the bank's discretion whether they want to initiate IBC proceedings if there is a default. So these amendments were basically made to ensure that the RBI also could control the actions of banks and mandatory refer specific cases of default to the IBC. So following this amendment, actually on the very next day, there was an authorization there's a central government notification on May 5th, 2017, which authorized the RBI to issue directions to any banking company or banking companies, which may may be considered necessary to initiate the insolvency resolution process in respect of a default under the provisions of the IBC. So this was the specific central government notification that gave the RBI authority under Section 35AA of the Banking Regulation Act to issue directions to banking companies to specifically initiate proceedings under the IBC. Following this, in May 2017, the RBI also announced the constitution of a committee to advise it in regard to which cases and which defaults specifically should be referred to the IBC. And in June 2017, it came up with this press release, which is very much talked about, where it recommended 12 accounts, which were the largest, which constituted about 25% of the NPAs of the banking sector. And they were all accounts where the amount of debt was over 5,000 crores for immediate reference under the IBC. This, of course, became the famous Big 12 cases. Some of them have been resolved, some of them the really big names such as Esser Steel, Bhushan Steel, Electro Steel, Monet is back. There are many, Amtech Auto, there are many of them here, and some of them are being resolved, some of them are in the process of being resolved. But this was how the Big 12, the banks were mandatorily required to initiate proceedings under the IBC. Subsequently, the RBI identified another 29 accounts also for mandatory reference under the IBC. So this was the RBI's actions in respect of specific companies and specific defaults where it said that the banks had to initiate proceedings under the IBC. Following this, in addition to this, the RBI also issued a circular in February 2018 for the resolution of stressed assets more generally. This circular did not identify specific accounts, but actually provided a framework for the resolution of stressed assets, which was to replace the erstwhile CDR and SDR schemes and all the other schemes that were in place previously for resolution of stressed assets outside the court or tribunal process. So this circular had a number of provisions, and some of the important ones, particularly for this judgment, are first of all, it required reporting of special mention accounts on borrower entities that had exposures of over 500 crores, and there were different stages, but it required reporting these issues right after the default occurred. And this circular also set about a pre-IBC framework, giving for lenders to arrive at a resolution plan before, without going into the IBC, a consensual resolution plan. And some of the most important features of this resolution plan was specifically for any accounts where the amount was over 2,000 crores, lenders were basically given 180 days from March 1st, 2018, or later on the date of the default, to arrive at a resolution plan. This resolution plan required 100% consensus among the lenders. And if that didn't happen, within 180 days, if a resolution could not be arrived at, lenders were then given an additional 15 days to mandatorily file an application under the IBC to commence proceedings for the corporate insolvency resolution process. And so basically within 195 days of a default, if there was any account which was over 2,000 crores, banks were required under this circular to initiate IBC proceedings. So this was the crux of what the February 2018 circular said. And now coming back to the Dharani Sugar's judgment, the petitioner's specific contentions were that basically they were all power companies, and they said that in this situation, a lot of power companies, and the reason for their stressed asset issue was due to factors beyond their control. There were changes in government policy, changes in tariff. There was the coal licenses, coal mining was limited. There was limited supply of coals, various factors, and they said that giving 180 days or 6 months to arrive at a resolution plan was completely unrealistic for power companies. They needed a much longer time scale, and therefore they said that the RBI couldn't just issue a very broad response that would be applicable to all companies. They would have to look at sector-specific approaches and couldn't just look very broadly at saying that any company where the amount is over 2,000 crores has to go into in IBC proceedings, have to be initiated after 180 days. Specifically, what the petitioner said were that the amendments to the Banking Regulation Act, the introduction of sections 35AA and 35AB, which we spoke about earlier, were unconstitutional because they were arbitrary, and they also suffered from absence of any guidelines, that they were just very broad and required banks to mandatorily that gave these RBI these very broad and arbitrary powers, and therefore it was unconstitutional. Secondly, they also said specifically that Section 30, that the February 2018 circular was ultra vires the Banking Regulation Act, saying that that was their alternative argument, that even if the amendments were for some reason valid, the RBI's powers under the circular were ultra vires the Banking Regulation Act. So what did the court say here? So first of all, the judgment upheld the Banking Regulation Act and those amendments that introduced Section 35AA and 35AB, pointed out that they were not arbitrary and there was sufficient guidance in the statutory provisions themselves as to how the RBI had to implement these provisions. The Supreme Court also pointed out that in economic legislation, a wide latitude had to be given to the government to decide how best to regulate matters, and also that even prior to the amendments that introduced Section 35AA and 35AB, the RBI, the Banking Regulation Act, gave the RBI a number of broad powers. Gave the RBI powers to control advances made by companies. And as we saw earlier, for example, Section 35A was very broad in the sense it gave powers to the RBI to issue directions to banking companies in a lot of cases in the public interest, if something was detrimental to the interests of depositors, to prevent the affairs of the banking company from being conducted in, in a detrimental manner to the public interest, to secure proper management, etc. So the Supreme Court said the RBI always had these broad powers, and introducing the amendments to the Banking Regulation Act did not in any way change the nature of these powers, and neither were they arbitrary. There seems to be a very clear reason why they were given under the Banking Regulation Act. And therefore, that it said that these amendments were not unconstitutional. So it upheld the Banking Regulation Act and the amendments made to that. However, it agreed with the petitioners that the RBI's February 28th circular was ultra vires the Banking Regulation Act. And its reasoning was as follows. It basically said that it looked very carefully at Section 35A, which was already in existence even prior to the amendments, as well as 35AA and 35AB. What it said was that Section 35A was technically very broad, and even under Section 35A, the RBI could have probably had the power to direct banks to initiate IBC proceedings, because it's very broad and general. It just says that it may issue directions to banking companies generally from time to time as it sees fit. So it was very broad, but because once Section 35AA was enacted, the RBI's powers, it was a very specific provision that dealt only with the RBI's powers to direct banking companies to initiate IBC proceedings. And therefore, once 35AA was enacted, any IBC proceedings could only be initiated under this section, because it not only gave the RBI powers to initiate IBC proceedings, it also laid down the method for doing so. And then coming to the next point of the Supreme Court, said that Section 35AA was very clear that two conditions needed to be satisfied in order to make a mandate for the RBI to be able to direct a banking company to make a mandatory reference. First of all, there needs to be authorization from the central government under Section 35AA, that's a requirement. And secondly, it is only with reference to specific defaults. It has to be specific defaults of specific companies, rather than referring to defaults generally, any defaults over 2,000 crores, etc. That Section 35AA was specifically only for specific defaults, and also required the authorization of from the central government. And the May press release of the government on May 5th, 2017, again, when it authorized the RBI under Section 35AA, it specifically mentioned in respect of a default. It did not say that the RBI could direct banks in respect of defaults generally, but mentioned very specifically that it was only in respect of specific defaults. And based on this analysis, the court concluded that the February 2018 circular did not deal with specific defaults. It was very broad and dealt with defaults generally over 2,000 crores, and said that any such circular which did not deal with specific defaults but dealt with defaults most generally would be ultra vires Section 35AA. And this is how the court came to strike down the circular in its entirety. Of course, it spoke primarily about this particular provision of the circular on mandatory reference to the IBC, but it made very clear that the circular is struck down in entirety. And also, very importantly, the judgment says that because the circular is struck down as in entirety as being ultra vires, it said that any actions taken under the said circular, including actions by which the insolvency code has been triggered, must fall along with the circular. And the way that I'll quote this specific sentence of the judgment, because it's quite important, it says, as a result, all cases in which debtors have been proceeded against by financial creditors under Section 7 of the Insolvency Code, only because of the operation of the impugned circular, will be proceedings which, being faulted at the very inception, are declared to be honest. So basically said that anything that is initiated solely on account of the circular will lapse. So since this happened, the RBI has said, it's issued a press release saying that in light of the Supreme Court's decision, it will look into the Supreme Court order and take necessary steps to issue new guidelines for the resolution of stressed assets, given that the February 2018 circular has been struck down. It's important to note here that the other powers of the RBI under the Banking Regulation Act remain intact. So Section 35AA, 35AB that give RBI powers to direct banking companies to resolve stressed assets in a particular manner, either outside the IBC or under the IBC, all of those powers remain intact. But the February 2018 circular and the framework it provides for resolution of stressed assets, including requiring any accounts over 2,000 crores to be mandatorily referred to the IBC if a resolution cannot be reached within 180 days, all of that was struck down as being ultra vires. So now coming to what that is the judgment and the issues that it considered in a nutshell. Now coming to what are the takeaways from the judgment, I will turn over to my partner Khyati to talk about some of the takeaways and what it means, the implications for ongoing as well as future IBC cases and the banks, the obligations of banks going forward.
So in our view, see, first with respect to the 12 cases, as well as the second list of 29 corporate debtors, we don't think that these actions that were taken under the IBC should be held void or in any way will be struck down. These should be able to continue. Also, with respect to certain other cases which came into effect, after the circular, which were brought in by the government after the circular, or any banks after the circular, this would depend on factual cases, whether this was solely under the circular or whether the banks would have in any case gone towards IBC as a resolution mechanism. It would be established on case by case basis. Now, interestingly, the circular and the circular being struck down doesn't in any way take away the rights of the banks to go to IBC. So it still continues that banks can represent that they in any case wanted to proceed with the proceedings under IBC. So therefore, they can just keep the cases that are ongoing may continue. But again, we don't know as of now what's happening, because so far nobody has contested anything and nothing has come up before any court. With respect to certain other things that had happened at that point of time, that because of the circular, the banks were required to mandatorily explain or mandatorily submit the details of any defaulting directors within on a weekly basis. Now the problem now, one thing is that it's unclear how the reporting requirements are with RBI right now. So with this one day rule being tossed out, the banks are currently not sure how they are supposed to report. But what we understand from sources is that they're continuing with the same reporting norms that were there under the circular till such time, at least till the a new circular is presented by the banks or by the RBI. Also, the earlier circulars before this Feb 12 circular came into effect, there were S4 guidelines, CDR guidelines, SDR guidelines. There was one important clause in, in the circulars that RBI had insisted on, was the bank should have the right to convert their debt into equity, and mandatorily every loan agreement that the bank signed, this clause should be provided to the bank. This right should be provided to the banks, and accordingly, appropriate resolutions should have to be issued by the borrowing companies. Now, it is unclear whether that clause is still in effect, it's not in effect. As a recommendation, we would feel that, banks should continue to insist on this clause at least till such time as, there's more clarity provided by RBI. Also, Aparna, is there something you would like to add over here?
No, no, continue and then I'll.
So the second thing is of the earlier schemes, whether those earlier schemes which were SDR, S4, or CDR, whether would they automatically come back into effect? So the answer, according to us, would be no over here, because considering RBI has also come out with a statement saying that they will be coming back with specific guidelines and everything. So right as of now, we don't see that those things coming in, those policies coming into effect immediately. So, best takeaway I think we have right now is to wait and watch a little. What we understand is the IBA, in anyways, has sent a recent communication to the RBI, where the IBA has, urged RBI to make a small relaxation in the new norms for stressed assets by requiring at least 90% of the lenders for approving a resolution plan instead of 100% that was mandated in the circular, and giving a time period of 270 days for implementing such plan. The ministry, basically the industry has been a bit speculative about this, because 90% doesn't help in any other way, in any way to what the contenders had in mind. The second thing is the IBA has asked RBI to set up a mechanism which is similar to JLF that was in place before the circular, also to provide a upgradation provision that if 10% of the outstanding debt is paid, then in that case the account itself could be upgraded back. This was not there in the earlier circular. Also, that to require the assets to be classified as a stressed assets, at least there's a default of 30 days before putting in any time limits. The power companies actually have sought a different treatment altogether. They've asked, at least 18 to 24 months for a revival, with the suggestion that, only after an approval of 60% of the creditors, then any resolution plan can go ahead. So, over to you, Aparna. That's
Okay, sure. Yeah, so as Khyati said, I think at the moment it is a wait and watch approach, to wait for the RBI circular to see what they come up with. One issue that, a couple of issues that are quite important are, one is what happens to ongoing cases. And the language that the ongoing cases specifically that were initiated after April 1st, 2018, and were of over 2,000 crores, so they fit into the circular. In our view, and the view mostly taken, we understand, by the market right now, is that because the judgment says very clearly that it's any proceedings initiated solely on account of the circular, it's not necessary that they immediately lapse. It's up to the banks whether they want to continue those proceedings or not, because the banks did always have the independent right under the IBC to initiate those proceedings in the first place. Of course, one thing it does do is it does mean that it makes many of these proceedings subject to, they could be challenged, and this could lead to more litigation on the, specifically with respect to these proceedings. The corporate debtor could challenge these proceedings. And in those cases, we think that it'll depend on whether the banks are able to demonstrate that they would have initiated IBC proceedings in any case, even without the circular, that it was an independent judgment call that they made, rather than solely on account of the circular. Another interesting question is, what about proceedings that were initiated, over 2,000 crores that were initiated after April 1st, 2018, where a resolution plan has already been approved? Can such cases be reopened? And that again, because typically the resolution plan is arrived at on a consensual basis, requires approval of the COC. It shouldn't be, but it does leave open the possibility that there can be litigation or contestation of resolution plans, even though they've been approved, if they try to contest that this the proceeding itself was not valid because it was initiated under the circular. So this is something going forward as well. We think it's likely that banks will have to show that they are exercising their judgment in initiating proceedings. The RBI is unlikely to stipulate again a one-size-fits-all approach. So there is going to be a little more. The banks are likely to have more discretion when they decide whether to initiate proceedings or not. It's also unlikely that the 180 will also give them more time to arrive at a resolution outside the IBC process, which could, I think that does go both ways. In one sense, it does give banks more discretion, allow them to exercise their judgment in deciding whether to initiate proceedings or where a resolution can be achieved outside the IBC. At the same time, it's also likely to delay resolutions. So that's something we'll have to wait and watch. But I think those are the main takeaways from this judgment. One other issue is the intercreditor agreement that was executed by a number of banks, largely on the basis of the resolution framework set out under the February 2018 circular. So what is the effect on this intercreditor agreement? This is a contractual agreement among lenders. So it doesn't fall away automatically, because lenders could always agree, regardless of the circular, to proceed with the specific resolution process. However, because it's really based on the circular and takes a lot of its provisions from the February 2018 circular, it's likely that it may need to be amended going forward. Again, this will probably happen only after the RBI issues a revised framework for the resolution of stressed assets. Khyati, do you have anything else to add on this?
Nothing further from me.
Okay. So we can take questions if there are any. Okay, I see there are no open questions, so thank you very much. If you are interested in this or would like a copy of the slides, please do let us know. Thank you.
Thank you.